Hey, this is Kent Jones with Jones and Associates PC in Cleveland, Tennessee. This is part 2 of Divorce in Tennessee, and I wanted to follow up on part 1 where we talked about ID divorces without children. A lot of times when divorces come in that the parties believe are uncontested, they end up really do becoming contested, sometimes just a little bit, and then sometimes to a great extent because they haven't communicated a lot during that time. If they become contested and there are no children, as we've been discussing about, then there is usually, we're talking about property division, asset division, and things of that nature. And all that's something, as I've discussed before, that's handled in a marital dissolution agreement, which is a contract between the parties. But if you can't come to an agreement on them, the courts are generally happy to hear those issues, but as you well know, the courts have a wide number of cases they have to hear during the day, so we recommend either agreeing upon a mediation or filing a motion to refer the case to mediation and get in there and handle those issues and get them knocked out. Again, the waiting period for a divorce without children is 60 days. Now, if you have children, the divorce is much more complicated, and there are a lot more issues to go over. And again, in many cases, we have agreed upon or ID divorces with children. But in cases with children, you're going to be dealing not only with an MDA, but you're going to be dealing with the permanent parenting plan, which is in Tennessee is a 9-page document that covers a lot of territory, including but not limited to residential parent for purposes of income tax, the time that each child each child spends with each parent, holiday schedules, exchange, place of exchange, insurance, major decisions, many other things. And additionally, what we do is we do a child support worksheet where you take the gross income of each parent, the time they're going to be spending with the child or children, and determine who owes child support and how much. You can see that adds a whole another dimension to the divorce process, and creates issues which make them more likely to become contested than in a divorce without children. Mediation usually works, as I've talked about before in previous discussions on mediation during divorce proceedings, so that's what we suggest. If worst case scenario, if you start off and there are all of a sudden immediate concerns with respect to the children, such as violent or threatening behavior, and you haven't broached the issue of divorce, you haven't gotten an attorney or anything, you can go to your local police department and get an order of protection to prevent the other party from doing any harm. If you already have an attorney, you're in the middle of the divorce process or beginning it, we can do it in court. That makes it a little bit easier on us because we can kind of control things there. And then in the other cases, which I guess would be the majority, you've got contested issues over the items in the permanent parenting plan that would be worked out in mediation. And when children are involved, the waiting period is 90 days instead of 60 before you can get a final decree of divorce. In the mediation process, at the end of it, you're going to want to decide how future disputes will be handled. You can handle them by mediation, you can handle them in court, you can handle them by agreement of the parties. Generally, what we end up doing is checking that we'll go back to mediation to resolve those newer issues. If the parents just absolutely cannot agree on anything at all, then your recourse is to bring the issues before a judge and have them decided in court. We'll talk more about divorce issues in part 3. I appreciate your time, and I hope everybody has a wonderful weekend.